We're ready with our second panel of the day. It is entitled Trade Practice Rules, Ensuring a Fair and Competitive Alcohol Marketplace. I would now like to welcome Fran O'Brien to the stage to moderate our next panel. Fran is a lawyer, lobbyist, and owner of FX O'Brien Associates, LLC. He represents licensees of all types across the Commonwealth on matters of licensing, transitions, and enforcement. Fran is no stranger to the Pennsylvania alcohol regulatory system with years of experience as a chief counsel to the Pennsylvania Liquor Control Board, as Assistant Attorney General for the Commonwealth, and as the chief counsel to the Pennsylvania State Police. Fran, let's get this exciting panel started.
Thanks, Mike. Our topic is, as you can see, what I'll describe as where the rubber meets the road. First panel, we heard a little bit about the background, why we have what we have. Now we want to focus a little bit more on, for especially the licensees in the room, what it is you have to do under some of these rules and regulations. We have the benefit of once again, another distinguished panel here today. The experience these gentlemen bring to the table in their various levels of jurisdiction is tough to beat. Rob Tobiassen was a lifer with TTB, retired chief counsel, general counsel. Mike Plank, almost lifer with the LCB as an assistant chief counsel, and Todd Merlina, another lifer with liquor enforcement. We may have reached the point in the marketplace of what I'll call a perfect storm. Certainly, agencies are all fighting for dollars to have enforcement budgets, to put enforcement people on the street. The greater increase in the industry and creating opportunities for time, place, location, alcohol availability, marketing, increased competition, et cetera, is really leading to challenges to the enforcement mechanisms. And when you end up with enforcement challenges such as that, you end up with different things happening in different parts of the state and different levels of the licensee community at different times. Ultimately, you end up with disconnects, and people tend to lose a sense of what they can do and what they can't do. So to help us parse through this, what I'll call the perfect storm, we have some excellent weather forecasters here who can give you some direction. And let's start off with Rob. Rob.
Good morning, and thank you, Fran, for that kind introduction. Thank you all for being here. I appreciate the Center's invitation to speak. It's going to be a legal presentation, in part a regulatory presentation, but as such we always throw out these disclaimers that this is for training purposes. It's interesting audience because in preparing for this presentation, I realize I have both policy for people here as well as regulators as well as industry members. And it's very important to talk to both audiences. It's very important for the policy makers to understand the underlying principles that regulate trade practices. So when they make policy decisions and new legislation and new regulations, they understand the purposes and they articulate those purposes. But we'll talk in a little bit why it's important to articulate those purposes. But it's also important for when you have the policy compliers, who I call the industry, who then have to live with those decisions of the policy makers. It's been said very much, and you will hear a consistent message, that alcohol is different. Justice Stevens dissented in the Granholm case. Justice Stevens was born in 1920. 1920 was the year Prohibition went into effect. And he points out in his dissent that he fears not everyone in a decision-making position understands truly the history of alcohol in the United States and the history that in 1919 led to the 18th Amendment and the history that in 1933 led to its repeal. Interesting, Justice Ginsburg, when she was sitting as a district court judge on the Federal Court of Appeals, made a similar observation in the Fedway case dealing with my former agency, ATF, at the time. Justice Ginsburg was born in 1933, the year Prohibition was repealed. So I did find it kind of ironic that they both had certain ties to those historic moments. But as she points out, there's a history to alcohol regulation that is the result of combating political corruption, combating business corruption. There's a history that, as referred, cheap alcohol is not an unmitigated social good, that it's a commodity that can be enjoyed reasonably, but it's a commodity that can be abused equally as well. Against that backdrop, again, what do we have as the basic policy reasons for the unfair trade practice provisions that we see? And these are generally the policies, the public policies that you see in play. You have obviously concurrent federal and state jurisdiction. It's been noted that under the 21st Amendment, states have been given significant authority over alcohol in ways they do not have authority over any other commodity. The concurrent jurisdiction means that you as an industry member, have to comply with both federal and state requirements. They prevent distortions of the competitive marketplace. And what we mean by that is they level the playing field. A lot of the promotional practices that come up in the unfair trade practice area, when we talk about product displays and category management, coupons, exclusive outlets, payments, slotting fee payments for preferred shelf space, those can be very, very expensive. They can be barriers to entry in certain areas. By having a level playing field, you allow more participants in the industry, and you get closer to some of the benefits of a truly competitive marketplace that aren't distorted in a situation where a retailer is carrying a product because of some undue influence being put forth by a particular trade practice. I think fundamentally what Congress was trying to get at in 1935 in allowing trade practices, but allowing limited trade practices, regulating promotions to a certain degree, was to say that retailers really should be stocking and selling products that they think consumers want, in the quantities they think consumers want. That the retailer should be pulling the demand for product and not having that demand created artificially but by pushes from improper trade practices. And this relates to consumer protection and public choice and product choice by the public, having products there that the public wants, not products there that some industry member thinks the public should want. Orderly marketplace has been talked about, and we talk about the independence of the three-tier system, orderly distributions. Under the 21st Amendment, orderly marketplace is one of what the courts have called the core powers of the states under the 21st Amendment, ensuring an orderly marketplace. And having independence in the distribution system encourages that orderliness. I think if you look at the literature on business governance, good business practices, if you look at public administration literature, you see that independent parties in transactions, independent parties, even within agencies, within corporations, independent entities, have a checks and balance against one another. That's why you have independent outside auditors in companies and not simply rely on inside auditors for activities. Independence between parties involved in a transaction inherently creates a certain checks and balance in the system. Business integrity in the alcohol industry, again, if you have products being sold because that's what the marketplace wants and not an artificial motivation for that sale through an improper trade practice, it encourages public confidence and public trust in the industry. If you have prohibitions on commercial bribery or pay-to-play slotting fee situations, again, those ensure business integrity, that the products being marketed at the retail level are again, the products the consumers want. And I say here that culture counts because it has been pointed out earlier in Mr. Ensley's slide that 34% of the country say, of adult consumers say they never consume. I mean, alcohol is a commodity that reflects a lot of cultural values, how it's consumed, how it's sold, how it's treated. And so you have to take into account the culture in which you're marketing your product. And the concurrent regulatory systems between the federal and the states, I think, do a wonderful job, offer that opportunity. Because you essentially have, and I'm going to go in fairly good detail about some of the federal requirements in a moment, but you have the federal requirements establishing nationwide standards, a basic level of trade practice regulation that applies in all 50 states in the District of Columbia. And slight tweak with the way malt beverages are handled, which we'll get into. But essentially, there's a federal level out there that applies nationwide. On the state level, you can then address those local needs, those specific local concerns that reflect your local public policies. And you can take into account the culture of your consuming community. There's a lot of history to where the federal government got in setting those basic benchmarks. They talk about the social and political evils that gave rise to prohibition. You see that a lot in the 1935 legislative history of the Federal Alcohol Administration Act, which is the principal federal law enforced by TTB on trade practices. And Pam Erickson went into some of those social evils. Mike's talked about the saloon history as well, about the vertical integration, about the pushes that came from the supply side to retailers they controlled to really push for overconsumption. Those were the social, political evils, corruption, government corruption, bribery, payments. Those were all the evils that came together in the perfect storm that led to prohibition. And those were also the evils that in 1935, from between 1933 and 1935, when the governments, both at the federal and state level, were trying to figure out how do we regulate this commodity so that history does not repeat itself. On the federal level, too, what Congress was looking at in 1935 was what does the federal government need to do to fill a gap where the states lack the authority? Because, again, the states have certain restrictions on what they can do with respect to interstate commerce activities or with respect to businesses, large companies located outside their borders. And so Congress was looking at how can they help the states, assist the states in regulating this industry. And again, you have these various public policy goals of preventing excess consumption, protecting the consumer, leveling the playing field. Trying to, again, ensure a marketplace out there where there can be, where entry is somewhat easy in terms of not being overpriced, where you can't be priced out of the market because a larger player can basically outspend you on promotional practices. Keep in mind, trade practice regulation is trying to ensure that everybody can compete equally in the marketplace in the sale of their products. Against that general overview and that policy, those policies, I want to discuss the federal requirements. You all should now have a copy of this publication, and instead of doing, and I need to actually, if Danielle could maybe bring in 3 more, I think the panelists may need copies, I'm not sure you guys have them. Rather than put up PowerPoint slides that go into excruciating detail about the various elements, I wanted to walk you through this publication a bit, because then you have a takeaway with you that helps you understand federal regulation. Paul Pisano, Paul is the General Counsel of the National Beer Wholesalers Association. He and I put this together. Paul has done a lot. He's a true believer in training and education. And I will say, unfortunately, with all the budget cutbacks in Washington, the Bureau doesn't do as much education and training as it really should, as it could do, because unfortunately, these rules are somewhat complicated. So this guide should give you a pretty good roadmap in which to walk through. There are essentially 4 basic federal unfair trade practices. There's the exclusive outlet, tied house, commercial bribery, and consignment sale provisions. But before getting to those, I mean, in the beginning of this guide, you have a little bit of the history that I've talked about, and then you get to who's covered. And I think this is a good checklist. For those who are policymakers, there are a lot of principles articulated here in the structure of this guide, which I think would help you when you develop policy to think about. Because again, first, who's covered by this? Who's the industry member covered? And how do you cover them? Who do you require to have a permit? Who do you require not to have a permit? Who's the industry member covered by this? The distiller, the winery, the brewer, the distributors, or the importers. On the federal level, they license at the supplier and the distributor level. Retailers are not licensed at the federal level. They are licensed only at the state level. There is a registration requirement at the federal level, but it's not a license requirement. Again, these laws, when they were enacted, were looking at how do the upper level tiers possibly unduly influence the lower level tiers. Essentially, in many ways, they were designed to protect retailers against more powerful upstream interests. I mean, today, the situation has changed where there are some very powerful retailers, and I think those of you in policy positions and policy areas really need to think about how do you address retailers, because a number of trade practice problems do originate with retailers right now, and this law in 1935 did not assume that the retailer, except in one area of consignment sales, might be doing something improper. Those of you who followed the recent case in Massachusetts involving the Craft Brew Guild noted that the state, the Commonwealth of Massachusetts, went after some of the retailers who essentially were found not culpable for some technicalities or some arguments that may still be going on. But that's the same, you're confronting the same problem that, maybe when you design your systems, you need to address retailers. And it's something, again, to keep in the back of your mind as you develop these policies going forward and your legislative proposals as you go forward. Again, who is covered? Whose conduct do you want to regulate? You also have to sometimes look at the conduct of third parties, because under the federal law, it's prohibited for an industry member directly, indirectly, or through an affiliate. Congress realized, and the agency realized, that when you undertake regulating this type of conduct, you have to figure out how the means to induce, how the things of value, how the agreements might be going forward. So, for instance, there was, when we talk about tied house, we'll talk a bit about the various things under the federal regulations, things of value that may be furnished to retailers, consumer advertising specialties, point of sale matters, product displays, retailer advertising specialties. There are some allowed things under the federal regulations. there were, in 2008, 2009, there was an investigation by TTB in the Las Vegas market involving Harris, where 6 suppliers went through a third-party promotion company. And they set up basically a bank at that company where Harris, as a retailer, could go in and draw down certain allowed things of value that were funded by the industry there. Now, TTB made its case saying, well, that was indirectly. You were providing indirectly. You can't do through a third-party entity, which is something you can't do directly. And so that case was looking at this situation where you go out and where you use a third party to do something. Looking at the 4 federal prohibitions, you have exclusive outlet. An exclusive outlet basically says under the federal law it's unlawful for an industry member, a supplier, an importer, a wholesaler. It's unlawful for an industry member to require by agreement or otherwise that a retailer purchase its products to the exclusion in whole or in part by those offered from another industry member in interstate or foreign commerce. The federal requirement, unfortunately, is more complicated than many state requirements. State requirements tend to be more clear-cut. You shall not do something unless it's expressly allowed. A lot of states are written that way. You cannot furnish anything of value. You cannot give any money. You cannot give a gift to a retailer unless it's expressly allowed. The federal statute has these additional requirements of exclusion, interstate commerce, and in the case of malt beverages, similar state law. What Congress was trying to say is we want to go after a violation if it has an adverse impact in the marketplace. We want to show that it's impacting adversely a competitor's product. And that was the traditional view, was a quantitative view. But then, following some court decisions, it also became a qualitative matter of not only does it affect quantities of sales of competitors' products, but it also is a type of practice that threatens retailer independence. And what the Bureau did, and that was a result of the Fedway case, the case that I cited with then Justice Ginsburg sitting as a circuit judge, where she said that exclusion means something that it's a practice that threatens retailer independence. So the Bureau in 1994-95 went through rulemaking, and the regulations lay out criteria. They set up a red light, a green light, and a yellow light process by which the Bureau looks to see, does this type of practice threaten retail independence? And it lists what we call red lights, which are practices which are found by definition to threaten retail independence. And then there are some green lights that, no, these are okay. And the yellow lights are, there are 6 criteria, and they're outlined later in this brochure pamphlet. There are 6 criteria that are utilized to determine whether or not retail independence is threatened. We also have to deal with similar state law in the case of malt beverages. In 1935, Congress struggled on how to deal with the brewing industry because in 1935, the brewing industry was very, very, very localized. And as I mentioned earlier, one of the things Congress was trying to do through the Federal Alcohol Administration Act was help the states in areas that the states couldn't on their own fully address. And there was a feeling, well, beer is local. You don't have nationwide brewers in 1935. It's pretty much a local industry. So states have adequate tools to address it. So the House of Representatives wanted to have brewers in completely. The Senate wanted to have brewers out completely, the beer industry out completely. And the compromise was a couple of things. One, brewers don't have basic permits. They don't have licenses. But they're still obligated to comply with the trade practice regulations, which means on enforcement tools, the Bureau has fewer enforcement tools, but it still does have enforcement tools against brewers. And it also came up with what became the similar state law requirement. The federal government said, okay, for trade practices, we'll let state law be the yardstick of enforcement. If a state has said this practice is bad, then if it's a practice we've identified at the federal level as improper, and the state also says it's improper, then we'll have an actionable federal violation. So for those of you in the brewing industry, you need to pay really close attention to the state law, because that will pretty much tell you whether or not the federal government has an actionable case against you if they're doing an unfair trade practice investigation. Exclusion is also in whole or in part. So as I mentioned, an exclusive outlet, it shall be unlawful to require an industry member by agreement or otherwise to purchase your product to the exclusion in whole or in parts of others. In part, exclusion in part can arise in various contexts. So for instance, the Las Vegas case that I mentioned, what the Bureau made the case because it said, well, some of these inducements, some of these freebies that you're furnishing through the third party are okay under the regulations, but you conditioned the furnishing of those on preferential shelf space, on preferential product placement. In that case, it was the well product for distilled spirits in a number of cases. So you could have, when you look at the exclusive outlet, excuse me, the exclusive outlet prohibition, it's because exclusion is in part, it can come up in the context of the well product. It can come up in the context of the draft taps. In the Massachusetts case that I mentioned, the Gill Brew case, that dealt with taps. So you can have exclusion in part. Other bottled beer can be there. Other products can be there. Or it's the house wine. Exclusion in part covers those types of situations where the industry member is targeting a particular display area, product display, marketing area of a retailer. You also have the tied house provisions, and they come up a lot. There are 7, and it's in the middle of the guide. There are 7 types of tied house arrangements that the federal government looks at. It's an interest in a retail license, an interest in the personal property of the retailer. The B3 is the real big one, the furnishing, giving, renting, lending, or selling to any retailer of any equipment, fixture, signs, supplies, money, services, or other things of value. The air you breathe is another thing of value. Everything is a thing of value. It's a very broad provision. Because it's such a broad provision, Congress did say, subject to regulatory exceptions. It's very important when you're looking at the federal regulation, when you're looking at the federal prohibitions on unfair trade practices, to really have the regs ahead of you. The regulations are available online. TTB does have a pamphlet with the regs in it, which you can request, and they'll provide it to you. Because you really need to know the exceptions. The exceptions are found in Part 6, Subpart D of Part 6 of the Trade Practice Regulations. And you really need to know what those exceptions are. And you need to follow them very carefully. And we'll come back to that in a moment, why. I just want to finish the other 4 types of means to induce, or paying accrediting a retailer for any advertising, display, or distribution service, guaranteeing a loan, extending credit beyond the usual and customary time, or requiring a retailer to take and dispose of a certain quota of product. That also covers a tie-in sale. Tie-in sales come up where you say, well, Mr. Retailer or Ms. Retailer, you want to buy this hot moving brand of product. I'll sell you 1 case of this product, but you have to buy 2 cases of this slow moving product. That's a tie-in sale, and that falls within the B7, the quota sale prohibition. But going back to B3, because that's really the ones where the things of value is where you see the investigations, and the B4 on displays, on advertising, display, or distribution services, paying or crediting a retailer for that. That's pretty much where TTB makes a lot of cases. I call these low-hanging fruit cases, and that's why the Bureau likes to make them, because a slotting fee, which is the term the Bureau uses for buying preferential shelf space, display space, is a red light under the regulations. So the Bureau has essentially proven exclusion if they can show the facts give rise to a slotting fee situation. So the Las Vegas case was a slotting fee situation. Earlier last year, the Bureau issued ruling 2016-1 dealing with essentially category management issues, schematics, shelf space. Those are issues that are addressed under this items 3 and 4. Basically, what the Bureau was saying there is the Bureau's regulations, and occasionally I use "are" just as force of habit, the Bureau's regulations allow schematics and shelf plan recommendations. The regulations were amended in 1994 and 1995 to allow an industry member to provide shelf schematics, shelf recommendations to retailers. That was a somewhat controversial rulemaking. There were public comments in opposition to doing that. The Bureau said it would revisit that if it was abused. Kendall Jackson Winery sent in comments opposing it. Wine Institute raised some concerns about it. So there was disagreement within the industry about whether or not shelf schematics should be allowed. Fast forwarding over time, we started to have category management. We started to have category captains, and that was all being done under the rubric of, well, this is really essentially shelf management, shelf plan recommendations, and the Bureau, you guys allowed them. The Bureau did a major investigation about, in the around 2012, 2011, 2012, they had a category management investigation going on that ended up not going to enforcement action. But the Bureau said they would issue some guidance. They were going to amend the regulations to address the category captain, category management schematics issue. But for a number of political reasons, the way Washington operates sometimes, the Bureau couldn't issue the rulemaking to amend the regs. So they were going to figure out ways of doing other guidance. In 2006, the ruling 2016-1 is kind of that storm coming together because the Bureau was trying to figure out how to issue guidance on shelf plan recommendations based on the previous investigation that they closed out. But then, as many of you probably know, in the end of 2015, Kroger came out with a Planogram Center of Excellence proposal that they were partnering with Southern Wine and Spirits on. And that gave rise to a lot of comments and concerns within the industry. And the whole argument was, how can a plan that complex be simply a schematic shelf recommendation plan? I mean, how do you drive an 18-wheeler through that little hole in the regulations? And so the Bureau sped up and got the guidance out, and that was the reason that guidance came out. A very important takeaway from that guidance, and why training is important and why presentations like the ones at this meeting and training are important, is the Bureau said, we never said category management and category captains were okay. You just assumed silence was an admission, it was okay. What we said in the regulations was something very specific and much more narrow. Never read more into the regulations than is stated in the regulations. Don't do magical thinking that something is allowed by the don't find good lawyers, like we have good lawyers in the room, I know. And sometimes you don't want to push them too far. Say, well, maybe it can fit in, maybe not. Don't always take the maybe. Regulations in the Bureau is saying they say no more than what they exactly say. And if you do something out there for a few years, don't assume that we're blessing it and saying it's okay by not taking enforcement action. There's any number of reasons we may not be able to take enforcement actions at this point in time. So I think that's an essential key takeaway from TTB ruling 2016-1. And that's why it's important to know the regulations. And in looking at those regulations, again, I just thought you really need to, I can only mention a couple there, things like product displays, and again, make sure dealer lotus, make sure that you know the regulation of product displays when you're coming up, when you're designing your dealer lotus. There are value limitations on it. It has to bear conspicuous advertising. There are a number, you can only condition the sale of one stocking of that display. Make sure you understand the regs. There are a lot of conditions imposed in the regulations. Again, there's a regulation that allows coupons to be given by industry members, by suppliers, to consumers. Coupons are okay under the regulations in Part 6 as an exception. But the regulation says furnished to consumers. The Bureau means by that the industry member has to furnish them directly to consumers. You don't give them to retailers to give to their favorite consumers. They have to go directly to the consumer. And I know there's been some questions about how coupons can be distributed through retail outlets or through retail premises. Read the regulations very carefully because they only mean exactly what they say. Every word has significance in that regulation. Moving on to commercial bribery, it's unlawful for an industry member to induce a trade buyer. Now, trade buyer is a retailer or a wholesaler. These last two regulations, the first two, exclusive outlet and tied house, were industry members' dealings with retailers. These last two deal with industry members' dealings with wholesalers and retailers for both commercial bribery and consignment sales. And it's unlawful for an industry member to induce a trade buyer to purchase its products through two types of commercial bribery. One is just called commercial bribery in the statute. That means a secret payment. That's where you basically, essentially hand money to a bartender to say, or you give the bartender, some cash equivalent like gift cards or something. You do something to get that bartender to say, look, you'll get this envelope once a month if you really push my beer. That's your traditional commercial bribery. Then the second type of commercial bribery is where the industry member offers a bonus, premium, or other compensation to an employee. That is a broader situation. That deals with things like sales promotion contests. Industry members may want to have a sales promotion contest, and those are, you're going to have to look at the regulations very carefully, how those are structured. That type of promotion contest is a means to induce, but it only gives rise to a violation if it results in exclusion under the federal statute. And the exclusion is the area where the Bureau has to look at it very carefully. So you really need to look at how some of those promotional sales contests are structured. Because you have to walk through your hoops very carefully, assuming you want to do one. The easiest thing is just not to do it. But if you do decide to have one, you really have to look at how it's structured to make sure it doesn't run afoul of the commercial bribery provision. And again, in the case of malt beverages, the consumer sales provision stands. Finally, I want to talk about consignment sales briefly. The consignment sales provision is interesting. It makes it unlawful to sell on consignment, conditional sale, with the privilege of return other than a bona fide sale. And it makes it unlawful to sell, for you to sell downstream, for an supplier to sell to a wholesaler on consignment, for a wholesaler to sell to a retailer on consignment. But it's the one provision that goes upstream as well. It also is unlawful for a retailer to ask you to sell to them on consignment, or for a wholesaler to ask to sell on consignment. So it's one of those that goes upstream and downstream. So it's important to follow in that regard. It also is the one area that doesn't require exclusion. So I call this another low-hanging fruit for the Bureau, because it doesn't require exclusion, so you just need the facts of of the case to basically essentially make your case. And you may be aware that in 2015 and 2016, both Miller Coors and Anheuser-Busch paid very large $300,000, $450,000 offers in compromise to TTB on a consignment sale violation. It dealt with seasonal products where they overstocked wholesalers, and they basically pushed overstocking, intended overstocking of seasonal products with an understanding they would buy it back after on the date, on the freshness dating basis. But because they were intentionally overstocking, the Bureau said you were creating basically a sale with the privilege of return that you knew at some point in some volume would trigger in. So the Bureau likes to make consignment sale cases because they're easy cases to make. You don't have to show exclusion. The interstate commerce element, which I haven't talked about, is generally not a problem in some cases, but in consignment sale cases, it's particularly easy because usually there were emails or faxes, so you had something flowing through a channel of interstate commerce, and that made the interstate commerce element very, very easy to meet. Just two things to throw in since I am in a control state. Basically, states who operate as in an area that requires a basic permit do not need them. So a state operating as a wholesaler doesn't need a basic permit as a wholesaler. And just FYI, it's a little broader for those of you who may get involved in issues. If another state agency operates a distillery or winery, it also doesn't need a basic permit. There are, in the University of California, for instance, has a number of wineries they operate as part of their training programs, and they don't need to have basic permits, so you find them other ways. And also this last provision is important to know the consignment sale provision applies to states as well. A number of the other provisions don't apply to activities done by the states. They apply to activities done by industry members to the states, but they don't apply to activities done by the state in the state's capacity. But the consignment sale provisions do. And consignment sales are easy, low-hanging fruit. So even if you're a state, you got to be real careful about those consignment sale provisions. I'd already talked about these cases. The top one is the ruling I mentioned on category management. The slotting fee case is the Massachusetts case. The Las Vegas cases. Go to these websites, find this. The Bureau has a lot of good information about these cases. I mentioned the slotting fee cases and the consignment sales. Overall, this is really the takeaway of everything I've been trying to say. And this is important for obviously a number of reasons. As we've said, alcohol is a socially controversial commodity. If you want to earn the public respect and public confidence, you have to market it in a responsible way. You have to do training so you know the rules. You don't want to get the press. It's not good press that the federal government's investigating you. No matter what people think of the federal government right now, there's still not good press that you are being investigated by the federal government. You want to build confidence and integrity in your community in addition to being, an independent business and a good corporate citizen. Again, you want to have a good compliance record in your community. I would also say to you who are policymakers, the last point I want to leave with you is there are recently, I think maybe the panel this afternoon that Professor Danning is going to be talking about, we'll get into some of these issues. There are some recent challenges to trade practices under the First Amendment, under commercial speech doctrine. There's one case in the Ninth Circuit in California dealing with a retail digital display. It's a company that said, okay, we'll go out and we'll give retailers free display monitors at their premises, and we'll sell advertising to, among other companies, alcohol companies, and we'll share some of our proceeds with the retailer. And that's a violation of California trade practice law. There's the retail RD, retailer network display, RND. RND, the plaintiff in that case, they filed a declaratory judgment against the state, arguing First Amendment grounds. They're saying, no, this is free speech. This is content-oriented messaging. Advertising is content-oriented material. Category management is also content-oriented material. It's where an industry member is giving a message, is giving content, substance, is giving a message to a retailer. That may be commercial speech under the First Amendment, entitled to, well, it is commercial speech and it is entitled to First Amendment protections. But the question becomes, what level of protection is it entitled to? Because the government can regulate commercial speech. Non-misleading commercial speech can be regulated, but the government has to show a compelling interest in regulating that. When you adopt these policies at the legislative level, at the regulatory level, you need to make sure that you articulate the basis for it. You have to articulate the public interest that you're advancing, because that is what the judge is going to look at in deciding whether or not you've made a case to withstand a First Amendment challenge to your statute or to your regulation. Thank you.
Thanks very much, Rob. What I think might make more sense is to hold questions till the end, because I think the various perspectives of federal, state, LCB, and state actual enforcement may come together to answer the same question. So at this time, we'd like to hear from Mike Plank with the state perspective on trade practice regulation.
Good morning. I am Mike Plank. I'm one of the lawyers for the Liquor Control Board. In our office, we have about 16 lawyers right now, I think, and that's headed by a chief counsel, Rod Diaz, who's been there for a long time. We're all based in Harrisburg. We're all in the same office, but we cover the whole state. And we're broken down into different areas of responsibility. What I do in particular, and we'll talk about a little bit more later, focuses on licensing and litigation. There was talk earlier about irresponsible licensees and people that get in trouble and that kind of thing. That's what I focus on. We have something like 18,000 licensees in Pennsylvania, and I really concentrate on those very, very few dozen or few hundred that catch our attention. I'll talk about that a little bit later. In addition to that, we have some people that focus more on the business side of things. Because we are the wholesaler for alcohol, we have warehouses that we do not own or operate. We have contracts with people that do that for us, and those can be quite complex, and there's a whole set of issues that arise from that. We also have several thousand employees, including many thousand in our stores, central office, in offices all over the state, so we have people that deal with that on a regular basis. And then we have a few people that deal almost solely with legislation and with regulatory matters, including drafting legislation, drafting regulations, interacting with the legislature, with lobbyists and other people involved with that. So we have people in our office that do that basically on a full-time basis. Rod Diaz, our chief counsel, has quite a good background in that and had that as his primary responsibility for many years. Of course, now that he's in charge of the whole office, he has the whole office to be in charge of. A couple of years ago, there was created at the LCB an Office of Legislative Affairs, which is separate from our office, which I think deals more with the sort of day-to-day interaction with the legislature and its staffers. And Brian here is from that office, I'm sure keeping an eye on me. So we kind of work with them, but getting back to what we do, in addition to all that, we are the lawyers for the board. So the fundamental relationship there is one that's very important to a lawyer. That's our client. And we owe our client, the duty of providing legal advice and representation, and that's what we do. Everybody else in the world, whether it's people calling in, whether it's legislators, whether it's industry members, distributors, licensees, those are just basically people asking us questions. And we give them answers, and we give them legally correct answers, but we stop short of providing them legal advice. We can't do that as lawyers. We can only legally advise our client. So we can tell everybody, look, here is what the law says. Only the board can we tell, and here's what your options are, here's what the consequences are, and here's what we recommend that you do. Everybody else, we just say, here's what the law is. Now, the short answer is that the board is our client. It's a little more complicated than that because we, of course, also have the Bureau of Licensing. Within the board, the Bureau of Licensing actually is responsible for investigating applications, for making objections when they are warranted, for doing evaluations, and they do take legal action in a lot of cases, which has legal effect. And so, again, in my job in particular, I more day-to-day am advising the Bureau of Licensing as the client in my day-to-day efforts. All of us are involved to some degree in the statutory side and the regulations, but as I said, there's a few of them that do it on a daily basis. And of course, this, literally the Bible of that is the Liquor Code. Title 47 of the Pennsylvania statutes. It looks like any other green book on the shelf, but it's something we all work with every day. It was alluded to a couple of times earlier that there was prohibition, and then there was, it was clear that prohibition was going to end in the early 30s. Our governor at that time, there was a great picture of him earlier, Gifford Pinchot, I think could be accurately described as a, an advocate of temperance. And he was very much against the return of the open saloon, as you heard. If you look at the Liquor Code, it's pages and pages of things that basically say, it starts with this proposition. Coming out of Prohibition, it starts with the proposition, you cannot have alcohol, period. You can't possess it, you can't sell it, you can't buy it, you just can't have it. The Liquor Code is basically several hundred pages of exceptions to that prohibition. And it's added to all the time. At the back of the book, as many statutory books, there's these very thin pages of updates, and those are added to quite frequently, usually every year. But the basic premise is one of prohibition, and then there's exceptions. And one of the exceptions is that, as we just heard a moment ago, the state can sell you wine and spirits. And that's true whether you're a licensee or just a retail consumer. The state is the distributor for, the retailer for off-premises consumption, for liquor and for wine. And of course, there's a different system for beer. But when you get back to the licensing side, the state stores are not licensed. They're run by us through our authority. For what we generally term on-premise consumption, what you think of as bars or taverns, of course, that's a licensing system. There are dozens of different kinds of licenses. We have little charts and everything. There is nobody that knows every single kind of license, nobody that I'm aware of. There are dozens of them, but there's a few that are really basic. The real ones we deal with day to day. The main one is a restaurant liquor license. Anything that you think of as a bar, again, this effort back in the 30s to banish the open saloon, there was a requirement that you serve food, that you have a certain number of seats and a certain square footage and that kind of thing, all of which was in opposition to the open saloon. So that's the basic type of license. There's also hotel licenses. There are club licenses of various kinds, which basically are for sales of alcohol only to members of that club. Those are really the basic ones we deal with on a regular basis. And I said, there's airport licenses, there's golf club licenses, there's just dozens of these things, performing arts facilities, but all have the same basic privilege, which is they can sell wine and liquor and beer, in most cases, to just regular people, non-licensees. And again, that's what we deal with on a regular basis. Now, you get back to the Liquor Code and the regulations, they basically apply to all those different kinds of licensees. But because there's so many different kinds of licensees and the licenses all have different privileges, of course, it's not all going to be one size fits all. As far as trade practice regulations, some of the things that we've heard about, pricing and that kind of thing, it is complex and it is complicated by the fact that you have these different kinds of licenses. Recently, as I'm sure you're probably all aware, beer distributors were given the privilege of selling not just in case quantities, but in any quantity. So beer distributors now can sell a single bottle of beer, they can sell a 6-pack of beer, they can sell a 12-pack of beer, and they can continue to sell a case or a keg or anything like that. But they're not treated as retail licensees in the way that restaurant licensees are under the code and the regulations. And so retail licensees like restaurants have very specific regulations regarding discounts. And basically, those have to do with happy hour promotions and daily drink specials, which they are permitted to offer. Beer distributors now can do the same thing. They can sell a single beer for off-premises consumption. They can sell a 6-pack just as a restaurant licensee can. But they're not subject to the happy hour rules. So that's just one example where it doesn't quite fit. There's not the same restrictions. And, you know, whether that's an equal playing field or not is for other people to decide. As lawyers, we're not policymakers. What we do is we take what our board wants to do, and how they arrive at that is, you know, through whatever. If it's the legislature that asks them to operate in a certain way or passes a law, we get our instruction from the board. We as lawyers don't make policy. We just draft whatever it is to make it happen. We also, as you probably know, in Pennsylvania, the board itself does not do direct day-to-day enforcement. The Pennsylvania State Police Bureau of Liquor Control Enforcement does the day-to-day enforcement of the liquor code and has done so for 30 years. 1987, that system was created. And I will tell you that literally every day I hear to the contrary. I hear somebody say that it's the board that does enforcement, that the board sent agents in to do whatever. We don't have agents in that sense. We don't have enforcement agents and have not for 30 years. So I'm sure you'll hear more about this in a moment, but the state police actually do that. They initiate enforcement actions which may culminate in citations issued against licensees. They have their own lawyers that prosecute those citations in front of administrative law judges. That Office of Administrative Law Judge is technically part of the Liquor Control Board. So we are the first level of appeal from that as the administrative agency. So in that sense, we're involved in enforcement as it works its way through the system, but not in the direct day-to-day stuff of deciding whether there's a violation or whether anything should be done about it. Where we do get involved, and where I in particular get involved, as I said a moment ago, is with licensees that have sort of run afoul of that. And that can be either because those licensees have been cited and those citations have been adjudicated, and now they've got a history of those citations. Then our Bureau of Licensing can object to the renewal of that license. And we essentially prosecute that, again, first at the administrative level. And that actually is, in that case, it's the Bureau of Licensing that brings the action. I would represent the Bureau of Licensing. And the board itself is the adjudicatory body, is the fact finder, and is the agency that would issue the order, either renewing the license or not renewing the license. And there's levels of appeal after that. One of the things that happens a lot, about 15 years ago, the legislature provided the board with the ability to enter into a conditional licensing agreement. And that is a negotiated instrument. It's not something we impose. The licensee has to agree to it. But if the licensee agrees to it and it's approved by the board, then that runs with the license and with the premises until further action removing it. So if the licensee is subject to non-renewal of its license, and at any stage this can happen, if a conditional licensing agreement or CLA is negotiated, then that would be in resolution of that objection. And we do these a lot. And a typical one would require them to get responsible alcohol management training. It might require them to add security. It might ask them to use an ID scanner on people coming in and buying alcohol, that kind of thing. So in addition to the statutory requirements that they're all subject to one way or another, the regulations that they're all subject to one way or another, a lot of licensees now have these conditional licensing agreements. We've kind of gotten to a mature point in this process now. As I said, it was about 15 years ago that this was implemented. So we've seen kind of a life cycle of these things where people have had them for a while. We've seen licensees that have had one, been objected to again, gotten a second one, maybe gotten a third one. And I can tell you that the thing that makes my job easiest is any licensee that breaches the CLA. That's real easy. Not that we win them all, but it's real easy for the Bureau of Licensing to decide to, again, object to the renewal of that license for a second or third time. It's real easy for the board to decide not to renew that license. And it's comparatively easy for me to convince a subsequent court, whether it's a Court of Common Pleas or the Commonwealth Court, to affirm that non-renewal of the license. Again, that's something that probably in a large scheme of thing, with 18,000 licensees out there, there's a few hundred CLAs. It's really not a high percentage, but it's what I deal with all the time, and it does impose additional requirements on that licensee, which they've agreed to. And it's a pretty easy, it's an easy path for us to ultimately non-renew that license if there are breaches of that CLA. And it's something that licensees really need to be aware of. As far as trade practices in general, I mentioned a minute ago about happy hours. That's been liberalized quite a bit. There's now, I think you can do 14 hours a week. It used to be much more restricted. And I'm not going to go through all the various changes to trade practices, but the general weight of this thing is that they have been greatly liberalized over the last 10 years or so, something like that. We have, on our website, we do a few things. One is that we do legislative updates. With these two big acts that were passed last year, Act 39 and Act 166, our legislative people really scrambled to put together guidelines to that. The first one runs something like 25 pages, just summarizing the changes to the liquor code that were made by the legislature. So those are on our website, and those go through. And you'll see, even when they did this, there was a lot of stuff, not a lot of stuff, but there were a few things that they weren't really sure what was meant, and they had to go back and ask the legislature, and we're still getting questions about some of that. Another thing we do is we do have advisory notices, which we publish from time to time, and that's a fairly it's a little more involved process than just the legislative updates. There is one on trade practices. It was last updated in 2012. It is Advisory Notice 10 on trade practices. It covers pretty much all the things you just heard about. Free drinks, relationships between manufacturers and retailers and all that sort of thing. The third thing we do, and we do this a lot, is we respond to questions that people have. And as I said a moment ago, we have one client, basically. That's the board. We advise the board. We give them recommendations. We give answers to everybody else. We try and give them answers, and we try and give them accurate answers. And we do have an instrument called an advisory opinion. If a licensee or an attorney for a licensee writes to us with a specific question as to how the law should be interpreted, we will give them an answer which is binding. We do publish that on our website for the guidance of everybody else. That is binding on the licensee. It's binding on the State Police Bureau of Liquor Control Enforcement. Of course, we don't answer anything that's pending. We don't answer, the state police came in and cited me for this, what do I do? We don't, if it's pending, we don't answer it, but if it's more of in the nature of a hypothetical, we answer it. We also answer questions from non-licensees. Those are not binding. We don't publish those, but we do respond to people that write in with those questions. Those are the advisory opinions, the legislative updates, and the advisory notices are all on our website. The other thing, as I said a minute ago, to go through all the changes and say exactly what they are, there wouldn't be time to do that even if we had all day. But basically, the trend of this thing is liberalizing it. It's making it more available. It's making it more available in more outlets. One thing that was mentioned in one of the earlier slides was the percentage of people that don't drink at all or that are light drinkers. And one thing I wanted to add to that was there's a lot of municipalities in Pennsylvania that are dry. It's still at the local level, you can choose to be dry in Pennsylvania. And I don't have the number, but there are a lot of them. And we get that question a lot, is my town dry? First, you have to define the question because you can be dry for a lot of different things. You can choose to prohibit beer distributors. You can choose to prohibit basically, bars, restaurant licensees. There's a whole list of questions, and unless you choose to not allow that kind of license, it's presumed that it is allowed. But there are a lot of municipalities that are dry for one thing or another. In addition to everything else that's happening with, basically you have grocery stores selling wine now, some of the other things, all the liberalization, I think we're starting to see a few more municipalities become interested in being not dry, being wet for certain things. And again, I think it's the grocery stores and the convenience stores to some degree that are pushing for that. And that's something that, again, we don't have a policy position on that. I don't think the board does, and I know our office does. That's something that's still very much at the local level. That's basically an overview of what we do, and if there are any questions later, I'll be happy to answer them then or afterwards. Thank you.
Thank you, Mike, for the Liquor Board perspective on it. This time, we'll hear from Todd Merlina from the Pennsylvania State Police Bureau of Liquor Control Enforcement. To Mike's point about who does enforcement, when we are actively lobbying on the Hill, and I'm spending a couple days a week on the Hill, I don't think a week goes by, and this is no slam at any of the legislative people who are in the room right now, that some member doesn't say, what do you mean the Liquor Board doesn't do enforcement? When did that change? How'd that happen? I say, well, legislature did it 30 years ago, but yes, there's still some confusion. But to clear the confusion, here's Todd from the Pennsylvania State Police.
Thanks, Fran. Again, my name's Todd Merlina. I supervise what's called the CAGE unit within the Pennsylvania State Police. Stands for Compliance, Auditing, and Gambling Enforcement. I started with enforcement in 1934, right after the appeal of Prohibition. So you're still awake. The reason I say that is I was an original LCB agent. I'm one of the only ones left. And in during the Civil War, or when the transition took place in 1987, you had your choice to stay with the board or to go with the state police. Obviously, I've made my career with the state police. When we fumble as the state police and do something wrong, we don't mind being called the LCB. But when we do something right, that's when we mind being called the LCB because obviously we're our own agency. So as a law enforcement officer, I'd like to know who are the licensees in the room? Because I don't have my ballistic vest on. I want to make sure I have a barrier between me depending on some of the things I talk about. Actually, you're going to find that, and I can speak for the command staff, that we are advocates of the industry. Most people think we in law enforcement and in alcohol enforcement are prohibitionists and we don't want anything to benefit you folks. That's not true. We are there. We are a resource for you. That's one of the things I do out of my office. I do nothing but answer questions constantly, whether it's on industry ideas or gambling or small games of chance or tavern games. I will tell you from an enforcement perspective that the industry in Pennsylvania is closer to the time before 1920 than we've ever been. We are very lax anymore. We're very proud of our enforcement and our industry here in Pennsylvania for many years because we were part of the Bible Belt. We were very strict. If you look at every legislative change that has taken place over the last 5 years, It has total promotion of sales and minimal safety concerns and minimal enforcement efforts. And I can go on all day and give you ideas of what they are. For example, off-premises catering. That gave 13,000 retailers 52 additional licenses to have an event off their premises anywhere in the Commonwealth of Pennsylvania. You do the math, but we didn't increase any enforcement. Let's talk about limited wineries. Not only the manufacturer, but you get 5 additional locations to the average person, looks like a bar room. The same thing for a manufacturer, a G license. Mike talked about a dry area in Pennsylvania. Well, guess what? That doesn't apply to a manufacturer. So a brewery can go into a dry township, or he can open one of his 2 storage areas to the average person that looks like a bar room, because there's now minimum food requirements for those manufacturers. So we're promoting the sale, we're promoting alcohol, the increase of consumption of alcohol. We talk about the expanded wine permit. So for a couple $1,000s, our retailers now can sell up to 3 liters of wine at any time that they're open. Well, who else do you think wants that privilege? And if anybody here from the spirit industry, they're obviously also introducing legislation. Does anybody need 3 liters of liquor at midnight? Like, what's the benefit of that? And you think that we're going to increase sales, but we're not going to increase any enforcement. There's going to be a lot of problems with that when you start selling those high volume alcohol things at that time of night. Who needs that? You know, the lady said this morning, shouldn't we plan as people in Pennsylvania to purchase, to have a party? Well, we have now removed that because we're open on Sundays from state stores, and now we can get beer, wine, and liquor just about any time during the day. Let's talk about our happy hours. So before, we had 2 hours a day, and then we could have a special of the day anytime, up to midnight. Well, now guess what we get to do? We get to bank our happy hours. So we get 2 hours a day, times 7 equals 14, and we can use them in any 4-hour portion. Who needs to drink at a discount for 4 hours? Do any of you know what happens during happy hour? People act like total idiots, because if I drink 10 drinks and I save 10 cents, that's $1. Like, one of my drinks could almost be free. So see how the industry is moving over my period of time in enforcement. It seems to be degrading to the industry, I personally feel. For you importers, we love working with you. You, again, are the first tier. You set the standard. You do a very nice job. Some things we are concerned about with our large venues. We see that there is a pay-to-play, and with our casinos, we want our product that we have the rights to in those certain venues. So we'd be all naive to think if there isn't pay-to-play occurring. Also, with the changing of our environment, the grocery and the convenience stores, to have the desired shelf space or the island ends. You know, we get calls constantly. You know, Frito-Lay, Pepsi, they all get that opportunity for that eye-level shelf space, and we're going to be naive to think that that's not also occurring in our industry here. With the recent privileges of the Ds and the IDs comes a lot of additional responsibility. And just talking with some of the gentlemen at my table there who are in the industry, they also realize that it's no longer hiring the employee who hands a case of beer over and collects $30. You now are going to be selling individual. You're going to be selling 6-packs. You're going to be selling growlers from a tap system. So with that additional, you now have to know how, your employees have to know how to check identifications. I manage the age compliance program in the state of Pennsylvania. We've done 15,000 checks since 2005. 5,000 times we've had an underage buyer served alcoholic beverages. It is 40% of the time we have an underage buyer who is in a sting operation who looks like they're 13, because we only use people that look much younger than their age, and about 40% of the time. And that's after they display a vertical driver's license. Folks, law enforcement and folks in the alcohol industry are the 2 people that are supposed to understand what a driver's license is. When I'm handed a vertical driver's license, it has a yellow line that says when I turn 18, so I can buy smokes, and it says when I turn 21. So 4 out of 10 times when we present that ID, the server still serves that minor alcohol. That's tragic is what that is. Because if it's 40% of the times when we run an age compliance check, How many times is a minor being served alcohol? Again, alcohol is becoming more accessible in the state of Pennsylvania than before 1920. Other things you got to worry about is ramp. You're now mandated to have people ramp certified. The board provides ramp program. It is an awesome program. It cracked me up until Act, 139 is when it required ramp. So in Pennsylvania, you had to have a license to cut hair, but you didn't have to have any training or any license to own a bar or to serve alcoholic beverages. So fortunately, that is the only thing in the most 3 recent legislative changes that increased any training or mandate or helpfulness to law enforcement. Your taps. You know, you never had to worry about taps. Has anybody ever gone into a bar and run a swizzle stick up in a tap? You would never drink draft beer again. And that's what the requirement is. You have to clean those taps and those lines every 7 days. Well, now you're going to be given the privilege to have growlers and keg beer. Are you going to be maintaining your tap systems? Because you've never maintained your Beermeister systems or your taps that you've rented out. Like if you rent a system, that is supposed to be clean. If you would soak a tap that you rented for a keg in hot water, you'd never buy draft beer again. So we have to get our standards of our health system up also, because now with these privileges, you're going to have more of this happening. We are going to be receiving the complaints. We receive 19,000 complaints a year. And you know who's your worst enemies? People in your industry. You are the industry that complains the most on each other, because God forbid that one person started to get the crowd and is making a little bit more money, so I'm going to complain on the individual that's down the street. We also now have to think about transportation issues, transporter for hires, because with this most recent legislative change, it's a puzzle now. So if my ID has territorial rights, that's the only rights that my D now has. Well, what about my D that's been servicing Dauphin County and he's in Cumberland County? Well, he no longer has those rights because my ID only has rights to Cumberland County. That's going to be a major concern. Discounting prices. That is such a war. Happy hours in the enforcement is probably the worst thing for the industry, because happy hours equal visibly intoxicated patrons. Visibly intoxicated patrons equal fatal accidents. And again, you'd be very naive to think that. You look down at some of our revitalization areas, the south side of Pittsburgh, 2nd Street in Harrisburg. There becomes a happy hour war to where we're promoting intoxication. Because I want the crowd, I'm going to have nickel beers. Well, what does that do? Is anybody really making money from a nickel draft? No. What you're doing is trying to lure the crowd away from all the other establishments. Well, now, what are you governed by as far as alcohol and discounting prices? So you've got to be aware of that also. I do have up here with me some handouts that we provide, how to check identifications. These are also on our website if anybody's interested. It is a quick education on people how to read. I also have some examples of what we call routine inspection. This is the inspection that you are subject to by enforcement. So if any IDs or Ds are here, we're not hiding anything. We're not doing anything secretive. We want you to know that we're looking at certain things so that then you are prepared to and have those things in order for us. So I'll stick around. I will give you my name and my phone number if you have any interest in calling me about anything. It is Todd Merlina, M-E-R-L-I-N-A, and I'm at 717-540-7410. And again, we would welcome the opportunity to talk to you, get things straightened out. That keeps us from having to investigate it further down the road when it's not on such good terms. Thanks.
Thanks very much, Todd. I've got some questions, and I'm sure people in the audience will. Briefly, Rob, because we don't have a lot of time for questions, what's the, as far as you know, what is the TTB's current posture regarding enforcement on trade practices? Are they looking at them? How do they focus? How do they get the ball started?
Yes, they are looking at them. Again, this is, I no longer officially associate with the Bureau, but in reading the public announcements from the Bureau. I think they are very interested in it. I base that on three things. The TTB annual report for fiscal year 2016 came out last week. It's available on the website, and it points out, I think on page 18, it talks about the ruling I talked about, 2016-1, and it says it's undertaking monitoring efforts to see if those guidelines are being followed by the industry. In the press release accepting the $750,000 OIC, offering compromise out of Massachusetts case, it also states TTB is continuing to monitor consignment sale investigations. And finally, it was announced a few weeks ago on the TTB webpage that the Market Compliance Office, which used to be on the policy side and headquarters operations, has a staff of 5 people. It was moved over to the Trade Investigations Division under Bob Angelo in the Office of Field Operations. Trade Investigations Division handles unfair trade practice investigations nationwide. They just got 5 new people, including one of those positions designated as a project manager for trade practice. Lisa Gessler is the person in that job. Those 3 things suggest to me the Bureau is wanting to dedicate resources to investigations. I will also say Lisa's name is at the end of ruling 2016-1. Her phone number and email is there. Lisa is very knowledgeable and very responsive on phone calls. Have any questions, give her a call.
Todd, are you aware of some of the out-of-state investigations, even by such as Massachusetts, about trade practices, and is that something the Bureau is looking at?
We are in contact with those folks on a national basis regularly, and we are looking at the same thing, because the thing in Massachusetts was actually a manufacturer that originated in Pennsylvania.
Questions from the audience?
Similarly, and this is for Todd, because there's a lot of additional attention on the trade practice stuff throughout the United States. And one of the things that the center has looked at is what can we do to help state enforcement agencies be better educated on and perhaps trained in identifying trade practice situations. Is there, you or with that national group you just talked about, some training, some tools,
Sure.
some forensic accounting? I mean, because some of these things are pretty difficult to find to your average enforcement person who's used to just checking licenses, doing the visibly intoxicated and you know, underage stuff.
That is a great point.
Whatever, are there some ideas you
There
have
are.
on
What we
could
would
do?
welcome is the opportunity, you know, for Rob to maybe provide some trainings with us, because the information he has is excellent. It all filters down and is mirrored on a statewide basis. So the more folks that are more familiar with what the trade laws are and the violations, that would be very helpful.
Are things such as gift cards and expensive dealer loader displays, Rob, maybe you can start, the most common types of things of value that are given for either displays, shelf space, perhaps tap access?
I can't say if they're the most common. They are obviously out there. And I think again, for dealer loaders, for end displays, product displays, you need to look at the regulations in Part 6. There are dollar limitations on the value. I think it's $300. There are conditions about prominent advertising material on the display. There are a number of conditions there. And gift cards, again, I mean, gift cards are money equivalent. And B3 is pretty broad. I mean, when it talks about furnishing anything of value, as I say, the air you breathe is a thing of value. Anything out there is a thing of value. So any of those things with a monetary value do raise a concern. And when they're in the context of preferential shelf spaces, display spaces, slotting fees, those are clearly areas that raise the Bureau's attention, because the Bureau has perfected a number of cases in that area, and so they know how to do it.
I guess this is for Mike. With the recent passage of, I think it was either Act 39 or 166 that required the ramp training, the ramp certification, which employees of a beer wholesaler, the ID, would have to have that training?
There, as you referred to, there's one of the acts just required that everybody who is an alcohol service personnel, as defined in the code, must have ramp training within 6 months of being hired, unless they had it prior to being hired by that licensee. And again, ramp is the responsible alcohol management program, which the board runs. And that's basically the answer, is that anybody whose job is defined as alcohol service personnel, and I think the language in there is whether it's primarily involved in the service of alcohol. It also includes doormen,
That's
door
correct.
people, security people, that, you know, you wouldn't have at a distributor, but lots of licensees have. And I think there's something either in the works or already, I think it's still in the works, that is going to permit other training to count as ramp. In other words, we get people a lot of times over the years that say, well, I took tips training, or was it serve safe, or something like that, and that has never counted as satisfying ramp, but I think that is, I think that's in the works.
Well, so with the IDs that sell to the other licensees, so is that for sales to consumers, or if they're selling to the other licensees, like your retail distributors and taverns and such?
You know, that specific question, I think we recently had put before us in some form, and I'm not sure that we have finished answering it, because that was one of the things that came out of these new acts, is we got a lot of questions like, okay, here's, you know, the sort of bold-faced stuff, but what about all these gray areas? And that was definitely exactly one of them. It was IDs, whether it was, I think one of the questions we had was, if you're doing just tastings or something, you know, you're not charging for it, does that count? If you do one and then you do one 6 months from now, does that count? If you do one a week from now, does that count? So those are still very much under review. I'm sorry I can't give you a more specific answer, but just in general, if anybody ever has any questions like that, you can call us and get at least an idea, maybe a better idea than what I just gave you. Or if you write into us, again, if you're a licensee, you will get an advisory opinion. It does take some time because all 16 or whatever of us have to read it and approve it.
Let me just add to that. I'm not sure as a licensee why you wouldn't have everybody in your whole organization ramp certified.
Mike, can legal opinions be requested online on the
Yeah, if you
website?
go on our website, you can reach us, you know, some people still write to us and put it in an envelope, put it in the mail. But most people email us or fax us something, and like I said, all the information's on the regular LCB website. What we do ask, though, is before you do that and, you know, put pen to paper or fingers to keyboard, is just do a quick search of our site and see that we haven't answered it 15,000 times before. Because we generally, I mean, for this new stuff, we haven't. But if you're asking us, you know, what's the rule on minors in licensed establishments, we've answered that quite a bit.
I get the question sometimes, conditional sales. Someone's having a big event and they want to know, you know, they're not intentionally over ordering, and they're not, you know, they're maybe ordering from different suppliers' products, but yet it's tough to estimate. You don't know whether it's going to be a cool day, a hot day. You don't know what the beer sales are going to be like. Any advice for somebody who really wants to comply with the law, but yet is faced with difficult circumstances?
You know, that's not really something that I think we're involved with at a day-to-day level. I think that's, I'm gonna say that's an enforcement problem.
I think we would look at each individual situation. What's the totality of the circumstances? Was it done intentionally, or was it done legitimately honest to where they just thought they were going to have more sales? Again, we're pretty reasonable, I think.
I see Rob checking the great book there.
Well, on the consignment sale provision, a sale with the privilege of return is a consignment sale. Now, there are exceptions in the statute and the regulations to certain ordinary and commercial reasons for returns, but overstocking is not one of them. It has to be a defective product or certain seasonal dealers. I would think it's a practical matter. If it happens once, probably people are not going to look at it. If you have a pattern or practice and you're doing it, I think, as Todd has mentioned, I mean, there are some times where people are every weekend somebody's doing something, and every weekend you're doing the same practice, and I think that could attract some attention.
Right. Well, how about if they just sat on the product till it was a week from out of code date? I mean, is that what the law?
You can, for beer, yeah, if it's beer, you can return it after the code date, but you did have that issue with both the Miller Coors and the Anheuser-Busch ICs, that they were intentionally overstocking with the understanding that they'd return it at
So
after
it was
the return
the
date.
pre-agreement.
So, there was an understanding that was
Good,
the situation.
Okay, thank you. Other questions? Yes, ma'am.
Hi, my name is Wendy Lewis. I'm a budget analyst with the Democratic House Appropriations Committee. My question is for Todd. You mentioned on the recent statutes that have opened up a lot more availability, but yet the enforcement has not increased along with it. From our perspective with policy, what can we do to try to get that into the budget? Are there benchmarks with other states on what is the cost of making certain changes to enforcement? Is there anything to measure against, or any way to?
I don't know
to
that you can
provide
look
that?
at it from that perspective. I think you have to take the number of potential licenses and divide that by the number of enforcement officers you have. Coming out of Prohibition, there were originally 40 agents for 600 eating establishments in 1934. 3 months later, they increased it to 85 agents. Now there's 18,000 licenses, and we have 165. So you do the math. We never proportionally increase enforcement to the number of licenses. And that 18,000 doesn't even include, like I talked about, the off-premises catering or the manufacturer storage that now can look like a bar. So I don't know. That would be much higher than my pay grade.
Fran, if I might mention too, ma'am, and Mike may have a copy of it, I think the Center for Alcohol Policies has a paper done by Mr. Gagliardi, Pat Gagliardi, entitled Deregulation Through Defunding, and it touches upon those issues. And I didn't notice a copy out on the table, but I'm pretty sure it's on the website. You'd be able to find it. Mr. Gagliardi is a former member of the state legislature in Michigan and knows a lot about the alcohol distribution system.
Yeah, I'm not sure, but perhaps we'll hear a little bit about that deregulation issue in this afternoon session. If there are any other questions, perhaps you could see us at the lunch break. We're certainly happy to have you here, and I will turn it back over to Mike Lashbrook. But finally, please, let's give another round of thanks to our panel.